Start. The cause of death, according to post-mortem report, was hemorrhage and shock due to ante-mortem injuries. Stop. The specific charge against the appellant was that he made the victim consume liquor to murder him. Stop. The inquest report and post-mortem report do not indicate that he consumed liquor. Stop. The viscera was not preserved so as to prove the prosecution case that the victim was made to consume liquor before he was done to death. Stop. Dr. S.K. Agnihotri, PW3, who conducted the post-mortem, was not examined on the said aspect. Stop. He stated that injuries could be sustained as a result of fall from tractor, that probable time of death could be 3/4 hours on either side from 8 p.m. Stop. It means that the victim was alive for more than 2 days after he left his house. Stop. The prosecution has not laid any evidence as to whether the tractor was taken to Haridwar or not, whether it was got loaded with bricks for sale at Haridwar as per the program, whether the accused and the victim were having any sale proceed in their possession or not, as the trolley admittedly was found empty with only victim lying in it. Stop. The entire rib cage was found broken. Stop. On dissection, the pleura, lungs, pericardium were found badly ruptured with tear and upper part of heart. Stop. The injuries were on both sides of the vertebral column. Stop. The person inflicting such serious injuries must have known that it would result in death of victim. Stop. It seems doubtful that such serious injuries would have been inflicted by the victim on the road in front of his home, which as per site plan is surrounded on both sides by village abadi. Stop. If on the other hand the injuries were inflicted at some lonely place, it is highly improbable that the accused would bring the victim back to village, place his body on his own tractor in front of his house, then himself go and inform his family. Stop. If it was as a result of fall from tractor, it could also be accidental. Stop. PW4, the investigating officer states that no blood stain was found on material exhibit 1, 2 and 3, that is kurta, pajama and vest of the victim. Stop. The prosecution has failed to explain how it is possible when the victim has received so serious ante-mortem injuries. Stop. The prosecution story is shrouded with mystery and does not rule out the possibility, as contended by learned counsel for the appellant, that someone had placed the body of the victim on the tractor trolley of the appellant after committing the crime, knowing that there was bitterness in their relationship and needle of suspicion would point towards the appellant. Stop. The prosecution has utterly failed to rule out other possible hypotheses. Para. We now proceed to examine the submission advanced on behalf of the state that Section 106 of the Evidence Act will come into play, as the dead body of the victim was recovered from the tractor trolley of the appellant. Stop. Section 106 of the Evidence Act is an exception to the general rule governing the burden of proof. Stop. It applies when certain fact is specially within the knowledge of a particular person and is not capable of being known by other persons. Stop. In State of West Bengal versus Mir Mohammad Umar 2000 SCC 1516, the Supreme Court explained Section 106 of the Evidence Act as follows. Para. In this context, we may profitably utilize the legal principle embodied in Section 106 of the Evidence Act, which reads as follows. When any fact is specially within the knowledge of any person, the burden of proving that fact is upon him. Stop. The section is not intended to relieve the prosecution of its burden to prove the guilt of the accused beyond reasonable doubt. Stop. But the section would apply two cases where the prosecution has succeeded in providing facts from which a reasonable inference can be drawn regarding the existence of certain other facts, unless the accused, by virtue of his special knowledge regarding such facts, failed to offer any explanation which might drive the court to draw a different inference. Para. Based on the principle enshrined in Section 106 of the Evidence Act, it was contended by learned AGA that since the appellant was the last person seen in company of the victim, therefore it would get attracted. Stop. It was further submitted that the dead body of the victim was found lying in the tractor trolley which belongs to the appellant and was found parked inside his house. Therefore, burden was upon the appellant to prove his innocence. Para. The theory of last seen in criminal cases propounded in context of Section 106 of the Evidence Act has been explained by Supreme Court State of Rajasthan versus Kashiram 2006 12 SCC 254 as follows. Para. The provisions of Section 106 of the Evidence Act itself are unambiguous and categoric in laying down that when any fact is specially within the knowledge of a person, the burden of proving that fact is upon him. Stop. Thus, if a person is last seen with the deceased, he must offer an explanation as to how and when he parted company. Stop. He must furnish an explanation which appears to the court to be probable and satisfactory. Stop. If he does so, he must be held to have discharged his burden. Stop. Section 106 does not shift the burden of proof in a criminal trial, which is always upon the prosecution. Para. In respect of an offence taking place inside the privacy of a house where the accused had the opportunity to plan and commit the offence, it is difficult for the prosecution to find out what happened inside the house. Stop. In such a situation, often recourse is taken to Section 106 of the Evidence Act to weigh the evidence. Stop. The inmates of the house cannot get away by simply keeping quiet and offering no explanation. Stop. However, the initial burden to establish the case still lies on the prosecution. Stop. It is only the nature and amount of evidence to establish the charge that is relaxed as compared to other cases of circumstantial evidence. Stop. The said principle has been laid down by Supreme Court in para 15 in Trimukh versus State of Maharashtra, reported in 2006 10 SCC 681 as